Okay. Final case on the docket is Randall versus Walt Disney World.
Good morning. Morning. May it please the court, John Paul Portel and Juan Bauta with the Farrell Law Firm on behalf of the appellant, Mrs. Margaret Randall. I'd like to reserve 5 minutes for rebuttal.
Okay.
Just by way of introduction, this is a case that was originally filed in Orange County. It was an underlying negligence and products liability case that was filed against the appellees, the Disney defendants, resulting from injuries that Mr. Barry Randall sustained following a ride on the Rock and Roll roller coaster. The case went into litigation. Discovery was conducted, parties attended mediation. In the ensuing course of that underlying personal injury action, where both Mr. Randall filed a claim on his behalf on his personal injuries, Mrs. Randall filed a loss consortium claim as well. Mr. Randall passed away. Fortunately, Mr. Randall and Mrs. Randall, they're English citizens and lived in England and were in England at the time that this occurred. In fact, there's record activity, a proposal for settlement, which the...
If we say that the trial court specifically considered the issue of excusable neglect and found that there wasn't any, what's our standard of review?
Well, Your Honor, I think there's two separate standards. I think just on the question of excusable neglect, it is an abuse of discretion standard. However, if you apply the strict interpretation of Rule 1.260, then that would be a de novo standard under the Metcalf case that we cited. And what we say there, Your Honor, is that when issues raised pertaining to the proper construction...
The rule does provide for excusable neglect to be an exception to the time limitations of the rule, right?
Correct.
All right, so the trial court, let's assume the trial court considered the issue of excusable neglect and found that based on what I've heard, there's been no showing of excusable neglect. Is our standard of review abuse of discretion, or is our standard of review something else?
I believe that based on the case law, in that instance, it would be just purely as to whether there was a sufficient showing of excusable neglect. It would be an abuse of discretion standard.
And that's an evidentiary showing or determination by the trial judge, correct?
That is correct, based on the case law. And so what the case that we cite, which is Stroh v. Dudley, it says specifically to the first point, it says, we hold that Rule 1.260A1 does not require mandatory non-discretionary dismissal, even in light of the terminology, quote, shall be dismissed to the deceased party. And so that's under the first application.
And essentially, the showing that you attempted to make to get around the rule and to say that this is an exception is that, and I can certainly understand that the spouse was so grief-stricken that there wasn't much that she could do at the time, and I can certainly understand how that could be an exception to the rule. But what's bothering me, and may have bothered the trial court, is that there's evidence that during this period of time, although I think it may have been after the time limitation of the rule, that the decedent spouse did have enough wherewithal and ability to file a probate proceeding in England at the time. So, I mean, that could have prompted the trial court to say, well, if that was the case and the spouse had the ability to do that, why didn't the spouse have the ability to at least try and comply with the rule at least a little bit sooner than she did?
Yes, Your Honor, let me address that point. I think it's a valid point. And the point is that what occurred here is that actually the plaintiff's attorneys, upon finding and discovering that Mr. Randall was deceased, we on our own went ahead and filed a suggestion of death, triggering that 90-day time period. And there's no obligation to do it any time before. It was never the defendants that had filed the suggestion of death.
I think the attorneys did all they could do in this particular case to see to it that the rule was complied with. It was just the client that...
Correct. And I think if you look at the Giuseppe case, as well as the standards on the Boudreaux, even though she may have filed for probate in England for whatever testamentary reasons. I don't think that it has a holding as to this separate cause of actions here in the United States regarding her husband's death. It's not necessarily triggered by one with the other.
The reason for noncompliance with the rule and the basis for what you consider to be excusable neglect was the fact that she was grief-stricken and just couldn't attend to the matter. She couldn't attend to this matter, but she could attend to the matter in England, and that doesn't make a lot of sense to me.
Well, and I think the discrepancy there is, Your Honor, is that it's not just about grief, which is what the defendants and the appellees argue as you look in Giuseppe. It's the combination of the grief and the failure to communicate, which is what her affidavit says. She may have been communicating with personal counsel in England on the testamentary issues, but in terms of this lawsuit, which is the personal injury action, the affidavit clearly states, attempts were made by my attorneys to contact me from the United States on this action, but because of my grief, I wasn't able to respond to it. She was busy in England dealing with the family affairs and dealing with whatever she had to do in terms of wrapping up once her husband passed away and their children. In terms of this lawsuit, the personal injury action, she was not paying attention to it, and that's what the affidavit says. So it's that lack of communication that triggers it.
I don't recall exactly how much time, so you can help me with this one.
Sure.
I'll go back and look it up. How much time elapsed between the time the decedent passed away and the time that she actually complied with the requirements?
The decedent passed away May 14th of 2010. Plaintiff's attorney first discovers this and files suggestion of death 8 months later, January 26, 2011. That triggers the 90-day window. Those 90 days would have expired pursuant to strict application of the rule on April 26, 2011. 27 days after that is when we filed the motion for leave to substitute the party and ask for the amendment. So that was on May 23rd, 2011.
So you're saying that there's a 27 or 28 days or something?
27 days exactly, if you go by the 90-day rule on the rule 1.260. So what we're saying is that this was a brief delay, and in fact, the Vico case versus Burkell that was cited by the defendants, in that case, it was also a similar thing where there was a delay in filing the substitution of counsel, and what the court looked at there was what was the excuse and inadvertence, and there the plaintiff's attorney said, well, gee, I didn't know that the rule was amended and that we had a 90-day window to file it. Also, in
Yes, in considering excusable neglect, do you think it's valid to consider the length of time between the date of death and the suggestion of death? For instance, if the suggestion of death had been filed one day after he died,
yes,
and so then the 90-day clock would end only 91 days after the death, which arguably is a short time for someone grief-stricken. But here, given that the suggestion of death was not filed for
8 months.
8 months,
Yeah.
8.5 months, and then you start the 3 months, and in 11.5 months, you still didn't have a substitution of parties. Isn't that something for us to consider in determining whether there's excusable neglect, or whether the trial court abused its discretion in finding no excusable neglect?
I don't believe so, Your Honor. And the reason is, and even if you look at the Stroh case, in that case, there was an 11-month delay, which is a case that we cited to, is a 14th 1985 case. And the reason is that under the normal statute, if you're going to file the wrongful death, you have 2 years. The only time that there's an affirmative obligation to act sooner is if there's a suggestion of death filed. And
Surely the rule doesn't contemplate that a suggestion of death would be filed, that length of time after the death actually occurred. Are there any rules or case law that says, the suggestion of death must be made a certain time after death?
I have not seen any, and I can't attest to what I've seen. Is I think what they refer to as a reasonable time, but what is reasonable? And so, for example, we have a question where there was an 11-month delay. Was that reasonable?
Under your theory, you could wait 2 years and then suggest the death and then, do it back.
Well, it would have to be before then, because it wouldn't state, even if you're going to suggest a death and assuming there's a wrongful death component, you would have to wait and do it that time. The reason behind that rule, the policy, and the reason why I think there's a time is that because this doesn't just apply in personal injury cases. It applies in cases where it might be a defendant, it might be someone who has a successor in interest. So if someone passes away, it could be in a commercial case. And so sometimes there's not a readily identifiable personal representative to be substituted. And it applies equally both for the plaintiff or the defendant. We've seen that in some of the cases we cited. So to say that there's a set rule, I don't believe that I've seen anything in the case. So I think it's just what's reasonable. I think that here, given that we first discovered it within 8 months, months, filed suggestion of death, and really in that process, we're trying to get a hold of the client to say, we need to make sure we appoint
Who made the suggestion of death in this case?
the plaintiff's attorney.
When did they know that he had passed away?
I believe it was at the following the suggestion of death by plaintiff's attorney, because when we first discovered it.
Okay, repeat that again, please.
Sure.
Does the record tell us when they knew?
The only record activity to that extent will be when the plaintiff filed its suggestion of death.
Because a suggestion of death can be filed by any party, I think.
Correct.
They could have filed it if they wanted to, and
They could
started
have.
the clock ticking earlier.
That's right, and they didn't.
That's why I asked, did the record indicate when they may have known? So,
I will represent to the court that the only record would be the date of the filing of the suggestion of death, because that's contemporaneous with the time that the plaintiff's attorney found out. We found out through personal counsel or co-counsel in England, he had died, we filed suggestion of death, and then ensued the
You're
process.
saying that the attorneys didn't know that he had passed
Correct.
away until
January of 2001.
And then when you found out, that's when you filed your suggestion of death.
Correct.
All right.
And so that's the grounds.
Let me ask you about
Yes.
the loss of consortium,
Yes, Judge Evans.
which is an interesting issue. Obviously, Mr. Randall's personal injury count was not disposed of on the merits.
Correct.
Let me ask you, if this case if this, incident happened at Disney, and for whatever reason, Mr. Randall decided he did not want to be a litigant, could Mrs. Randall have filed a loss of consortium claim on her own, bringing a negligence action for loss of consortium against Disney?
I believe that the answer to that is yes.
Because it seems to me that's kind of where we are in this situation.
Correct. And that's the Taylor case. And really, it's an important binding decision from this district court. But the Taylor case, one of the cases that the police cite to, it's a 1971 Florida Supreme Court case, Gates v. Foley. And actually, I think that's a seminal case, because for the first time, it recognized that a wife has a viable loss of consortium claim. And that was based on the prior decision in 1950, I think it was 1955, the Busby case, where there the Florida Supreme Court recognized that a husband has an independent cause of action for loss of consortium. And even though it's derivative, it's still independent to him. And so in the Gates case, they recognized, because we want to do away with sexual inequalities, we are going to recognize that a wife similarly has a loss of consortium claim. And so in that case, the wife had actually, in the Gates case, the wife on her own filed a lawsuit.
So
Loss of consortium.
in that situation, then, are you going to have a condition precedent to the loss of consortium claim where the person bringing the claim for loss of consortium has to prove a viable personal injury claim, in essence, a trial within a trial, in order to recover on that loss of consortium?
Yes, and the reason is I'm citing to the Florida Supreme Court's case of Gates, which says is that where there's a cause of action brought by the injured husband pending, the wife's consortium action, if not time-barred, may be joined with the husband's claim. Or a separate suit has been filed, consolidated for the purpose of the trial. The defendant has a right to request joinder of the wife as a proper party to an action brought by her husband if she has not filed suit on her own behalf. And here's important language. Where the husband's cause of action has been terminated by adverse judgment on the merits, this should bar the wife's cause of action for consortium. However, because where there's no affirmative finding against the merits of the case, so here in the personal injury, even though it might abate because he's no longer alive, the loss of consortium claim, which is what the Taylor Court says,
I think
still
the law is
survives.
pretty clear that the consortium claim is derivative only in that it's dependent on a finding of liability in the main claim of personal injury. I think the law is pretty clear on that.
But it doesn't mean here where, because Mr. Randall deceased, it doesn't mean just because that claim doesn't go away, we were allowed to have amended and filed the survival action on the 46.021, we can still have the loss of consortium. Or if it's a wrongful death in the alternative, then that does do away with the loss of consortium, because the loss of consortium gets wrapped into element of damages and wrongful death. So if the court has no other questions, I guess reserve the rest of my time for rebuttal.
May it please the court, My name is Doug Stein. I represent the Disney appellees. Your Honors, let me start with the standard of review. There's no question of any interpretation of the Florida Rule of Civil Procedure here. It is the application of the rule, and that is subject to an abuse of discretion standard.
And what's strange about the abuse of discretion standard, and I agree that's what the law says on that point, is that we have the exact same evidence the trial judge had. I'm not saying we agree or disagree with the trial judge's ruling, but really all the trial judge had was an affidavit and the dates that we have. So, usually the abuse of discretion standard is out of deference to the trial judge having the opportunity to view the credibility of the witnesses and, make credibility and demeanor determinations. So it's just kind of a different, to me, abuse of discretion standard here in that we have the exact same evidence, or tell me if I'm wrong, we have the exact same evidence that the trial judge had.
Well, I think that it's the same as a usual abuse of discretion review in that it is the exact same evidence, whether there's a lot of evidence or just a little bit of evidence, there's the same evidence before Your Honors that was before the trial court. The question is, when there's a smaller amount of evidence, maybe there's less to interpret or something to that extent. But the real question is, and I guess what the abuse of discretion standard says, could reasonable men differ? So the real question is...
About that, because opposing counsel indicated that they didn't know about the decedent's death until some 8 months after the decedent actually died, and then once they found out, they filed this suggestion of death. You could have filed a suggestion of death too, had you known about it too.
Correct.
And then they filed a suggestion of death about 8 months after the death actually occurred, and then the 90 days went, and then approximately 27 days later, they complied with what they were supposed to do. Don't you think that based on those facts and circumstances, if they didn't discover it until 8 months, and once they did discover it, they filed a suggestion of death, and the 27 days of missing the deadline, isn't that an extremely harsh result?
No, Judge, not at all.
You don't think so?
I don't think it's a harsh result for a variety of reasons.
Based on the fact that she was grief-stricken to the point where she just couldn't attend to the matter within the 27 days.
Well, we can talk about that, Judge, because I think the premise that she couldn't attend to the matter within 27 days is absolutely a false premise that's been presented in this case. Let me first, before I even get to there is no evidence whatsoever in this record that anybody, including the plaintiff's lawyers, did not know about the death before 8 months. But let's assume that they didn't.
Well, okay.
Okay? The wife obviously knew. And
Well, just point me in the record where, opposing counsel's statement is absolutely disputed that they knew about it sooner than the 8 months. I mean, is there anything in the record that says...
no, there's nothing in the record one way or the other.
We kind of have to take their word for it, that they didn't know until 8 months later.
That's fine.
And then when they knew, they filed a suggestion.
Fine. I mean, the wife obviously knew. And the premise of the wife's argument in this case as to excusable neglect, first of all, it has changed. It started initially as, I couldn't get a personal representative appointed in time, so that was the purpose of the delay. But once the suggestion of death was filed, she was able to get a personal representative appointed. They still had plenty of time. I believe it was still more than 2 months left. Excuse me.
The probate in England was open, about 30 days after the suggestion of death?
I think that's correct, Your Honor. So, first of all, once it was learned that the death had occurred, there still was no reason whatsoever to file the suggestion of death if the plaintiff herself was not ready to proceed with the case, because once the suggestion of death is filed, as anybody who reads the rule knows, it starts the 90-day clock ticking. We didn't file it, they filed it.
Well, and I know they could have filed a motion for an extension of time and all of that, and there's nothing in the record to indicate they did that, did they?
They did not do that, and that certainly was another option for them. And the suggestion, I don't mean to interrupt your thought, Your Honor, but the suggestion that the plaintiff then changed.
If I can switch gears for just a minute.
Yes.
While this is on my mind, it has to do with the consortium claim. that is an independent claim, although it is derivative from the main claim, and it's derivative because you have to establish the liability in the main claim to enable the spouse to obtain consortium. And if we agree with you in this particular case that they just completely missed the deadline and excusable neglect wasn't shown, the consortium claim would still move forward, wouldn't it?
Not under this case, Your Honor, not in this case. Because what the Supreme Court said in the Faulkner case was that the consortium claim is premised on the spouse's, the deceased spouse's ability to recover. In this case, Mr. Randall or his estate.
Is it recovery or is it liability?
Recovery, Judge. I can quote from Faulkner. It's the husband, in that case it was the husband, as in this case, the husband's ability to recover. And in this case, Mr. Randall nor his estate has an ability to recover.
Yeah, let me back up so my hypothetical that I gave earlier about if Mr. Randall didn't want to bring this action on day one, and Mrs. Randall did, would you agree that she could have brought her separate, independent, derivative, loss of consortium claim?
Correct. The law is that does not have to be joined.
So you're saying that because he no longer has the ability, to recover, even though the case hasn't been resolved on the merits, she lost hers as well?
Absolutely, Judge, because he no longer has an ability to recover. That's what happened in the Faulkner case. In the Faulkner case, this is a little bit different. There is no case like this case, and I'll talk about Taylor in a second, because Taylor has nothing to do with this case. But
if she wanted to bring a consortium claim independently, and she did, and she established all the elements of the cause of action of negligence and established her damages for consortium, she would be able to recover, wouldn't she?
if she was able to prove that Mr. Randall would also have been able to recover. That's, as one of your honors discussed, that would be a trial within a trial.
Are you saying that the fact that they missed the deadline constitutes a merits determination of the negligence issues in this case?
No, but it is a determination.
So the merits of the case have not actually been determined yet, have they?
That is correct.
Right.
But it is a determination that Mr. Randall cannot recover, and that's what the law says. That's what Faulkner says.
Okay, so going back to my hypothetical, if he doesn't want to bring an action, she does. So she files her complaint, she's got a viable complaint. Then a couple months later, he decides, you know what, I am going to bring my personal injury action. So he files his, maybe they get consolidated, and then this happens. You know, he dies, there's no timely substitution, etc. You're saying that even though she's done nothing wrong legally in that context, that her cause of action disappears because his estate messed up?
Correct. It's not a question of her doing anything wrong or not wrong. It's a question of what is the legal basis of her claim.
And you're relying on Supreme Court language, you know, as far as the ability to recover. Now, is that use of the term ability to recover, is that part of the holding, or is that dicta in that case?
It was part of the holding. I mean, what the court said, and I'll quote, this is Faulkner at page 217, the claim for loss of consortium is derivative in nature and wholly dependent on her husband's ability to recover. Now,
I mean, you can interpret that any way you want to. I mean, I just think that there has to be a finding of liability and negligence, and that she gets to come in and prove her damages. I mean, I think that's what the court meant. But I mean, if the courts get to the point where they cut off a consortium claim based on the fact that they missed by 27 days the deadline under the rule, then I think the Supreme Court can say that. Maybe this is a case where we should write on it and certify a question, but I don't read the case that way.
okay, I understand that, Judge. I understand. But all I can present to you, Your Honor, is what the Supreme Court has stated. And for instance, in that Faulkner case, what happened there was that it was determined that the husband damages or injuries didn't reach the permanency threshold. So he had a perfectly good cause of action that he presented, but he was unable under the law to recover for his injuries because of that, if we want to call it technicality, that he hadn't reached the required level under the applicable statute. That's very akin to what's happened here.
But that recover refer to, on day one, if you would, he didn't have the ability to recover, as opposed to losing that ability because of a non-compliance with a rule of procedure.
Well, in Faulkner, which was the case where that language comes out of, the husband had the ability to recover on day one. He had to prove his ability to recover. He had to sustain that ability to recover, and during the trial process, he was unable to do that.
But by the jury's finding that he had no permanent injury, in essence, that was a finding that on day one, he did not have the ability to recover.
I would say that's true. Okay. Yes. So, let me return back to...
Interesting issue.
Oh, no question about it. It is an interesting issue. And let me just...
How are you differentiating Taylor for us?
What happened in Taylor was that a wife asserted the claim for loss of consortium, and I believe it was a medical malpractice claim. And of course, the husband was claiming personal injury as a result of the medical malpractice. In the middle of I believe it was the middle of the trial, he passed away. It was undisputed in that case that he passed away from the medical malpractice injuries, unlike in this case where the plaintiff alleges they're not sure whether he passed away from what's alleged to be the negligence of Disney or whether he passed away from another cause, which is stated in the certificate of death in this case as being bladder cancer. The wife in Taylor did file a motion, a suggestion of death, and timely filed a motion to substitute. That should end it right there, because there was unlike in our case, there was an untimely motion to substitute. There was a timely motion to substitute. The wife also filed a separate wrongful death action. What the Taylor court analyzed, they analyzed that there are three separate actions or claims at issue in the case. Number one is a loss of consortium case. Number one was the personal injury case. Number two was the personal injury case. Number three was the wrongful death case. In regard to the personal injury case, the court held that abated, that went away upon the death. As to the wrongful death action, the court held that it was an invalid splitting of causes of action. Therefore, it dismissed the wrongful death action. As to the loss of consortium claim, the court held that the loss of consortium claim can exist even though the personal injury claim of the husband abated and went away.
Well, it says personal injury action cannot survive the death, and that's
Correct.
why you have the wrongful death action. So
Correct.
That's how your recovery is determined under the Wrongful Death Act. So Taylor did say that if the personal injury action does not survive the death, the consortium claim does.
That is correct. And
In this particular case, the personal injury action did not survive his death, and he does not get to recover under the Wrongful Death Act because they didn't file the suggestion or they didn't comply with the rule within the 90 days.
that is not what Taylor says, Your Honor. I'm sorry.
Well, I know, but I'm saying that you're interpreting it
understand.
a wholly different way.
Well, what we're saying, first of all, Taylor, we would wholeheartedly disagree respectfully with the previous panel in Taylor. We believe that once the personal injury action goes away...
At least it was overruled on other grounds.
Well, it was, and in fact, I would argue that...
Does that necessarily mean that the entire case goes away?
Well, what's interesting, Judge, what the Supreme Court said when it said it's overruling Taylor to the extent that it's inconsistent with, I think that was in the Capone case, the recent case. What they said in the Capone case was that you can maintain at the same time a personal injury action and a wrongful death action if you're unsure as to what caused the death. In Taylor, that wasn't the case. In Taylor, they were sure what caused the death. It was the medical malpractice. Therefore, all that existed was the wrongful death claim. The personal injury claim could not exist. So I understand.
That's not, I mean, I had the Capone case, and I think the wording is pretty interesting here. As it talks about Taylor, it says, based upon this conclusion, we hold that when a personal injury action abates pursuant to section 76820, this does not require that the entire case be deemed immediately void and must be dismissed, or that it, and this is pretty cool wording right here, it self-destructs like the secret message on a rerun of Mission Impossible.
Correct.
I just thought that was pretty cool. So
It was.
I wanted to read that
And-
into the record.
Yes.
So I don't know, I mean, for me, that doesn't, that's not concrete that, for lack of a better term, Taylor is dead and...
Well, what Capone was referring to when it used that descriptive language, because in Capone, it was, as in our case, there was a potential personal injury action. So the loss of consortium claim could attach to that potential personal injury action because they were unsure as to what caused the death. Of course, in our case, we would argue, even if it could attach, it doesn't in our case because they didn't comply with the 90-day rule, and I understand Your Honor's thoughts on that. But in Taylor, there was no personal injury action upon which the loss of consortium could attach because they were sure that the medical malpractice injury caused the death. So there could be no personal injury action, only a wrongful death action. So what Taylor held was that a loss of consortium claim can exist when the only other action that is pending is a wrongful death action. We would submit that that is absolutely wrong. That doesn't comply with any case that's out there. The Third District held contrary, and it doesn't seem to comport with the intent of the legislature, which, when it enacted the Wrongful Death Act, included the same exact loss of consortium damages that would otherwise be obtainable when it attaches to a personal injury action. So what's interesting about Taylor, since we don't know what was going on in the minds of those judges on that panel at the time, but because it held that the wrongful death action could not go forward because the trial could go forward in that case, maybe that's why the court in that case stated, well, the loss of consortium claim can exist. But now that we know that the wrongful death action can go forward, and you can't even coexist with a potential personal injury action, so the loss of consortium claim can attach to the personal injury action, maybe Taylor would have been decided differently if it had ruled the way that we think it should have ruled. So we would submit that Taylor really has been overruled by the Supreme Court Capone case. I would like to return to the first part of the argument in regard to excusable neglect, and maybe address some of the questions that Your Honors had. Once again, the suggestion of death was filed 8 months after the actual death, and perhaps the plaintiff didn't know that the death had occurred until 8 months after. But again, it was the plaintiff's choice to file the suggestion of death at that point. There was no need to file the suggestion of death. Once they filed the suggestion of death, it started that clock ticking. In regard to the plaintiff herself, her excuse that she couldn't respond to her lawyers here, I think counsel said, well, that the affidavit says that she couldn't attend to matters in the United States. The affidavit doesn't say that. There's no differentiation between what was occurring in England, which there's really no evidence of what was occurring in England other than that there was some sort of probate going on there, and what occurred in the United States. She was able to attend to whatever matters needed to be attended to in England to probate the estate. They were able to file the motion or the suggestion of death in this case. So that was for the trial court to decide how to view that excuse and apply his discretion in determining whether it was excusable neglect under those circumstances. Based on what we know did happen, there is absolutely nothing to indicate that she couldn't have responded to her lawyers in this case. And there's no explanation as to why she even needed to respond to her lawyers in this case. She was a party in this case. I don't know of any rule that requires a lawyer to obtain permission to continue on with a case, maybe perhaps to dismiss a case or to end a case. There's no explanation in the record as to why it was necessary for her to respond to the lawyers. And, of course, there is no explanation whatsoever in the record as to why, before the expiration of the 90 days, that there wasn't a motion filed to extend the time, which then would have, if it had been granted, would have prevented the dismissal, and we wouldn't be here talking about excusable neglect if it had been denied.
You're over your time.
Thank you, Your Honors.
Okay, thank you.
I may briefly, Your Honor.
Why didn't he just file a motion to extend the time?
Your Honor, that was inadvertence and mistake on our part, and that's the reality situation. Had we done that, you're right, we wouldn't have been here. That's absolutely right. Had we filed the motion for extension time, then we wouldn't have been here. And essentially what happens, we filed the motion for substitution, and we walked into a hearing a year later, and there was, for administrative reasons, even though it was set 5 times, we weren't able to finally get it set for hearing. At no point in time did the defendants ever file an opposition, move to dismiss. So essentially, we walked into the hearing on what appeared to be an unopposed motion. And then at that point, there was a more tennis motion to dismiss made
Why
on the
don't
rule.
you respond to his argument about the Taylor case, that essentially it's not any good anymore, and we shouldn't even bother to...
Absolutely, and I like to point to the Faulkner case that he addressed, and that case is very important, because what that case says is that there was a failure to show a prima facie showing of meeting the no-fault threshold on the husband's underlying primary case. So that was a decision on the merits. So essentially, akin to this case would be like saying, the Disney defendants were not negligent. The Disney defendants were not liable for strict liability. Therefore, the wife's derivative claim no longer exists because the underlying case is no longer viable. That's what Faulkner addressed. So it says if the underlying case on its merits, there's no finding prima facie showing is not valid, therefore the derivative claim is not valid. That has not occurred in this case. So on the Taylor case, and which is important because the Capone case does address this, and Judge Wallace pointed to language. The language that Judge Wallace pointed to actually comes from the second DCA case in Miami, which Capone, in the Florida Supreme Court, they reversed the third district Capone case, but approved Miami. And Miami, in that case, even the second DCA in Dicta said the loss of consortium claim still remains, it appears like it still remains viable. And so the Taylor case, all Taylor said was, and it said very specifically in the case, and it has it, I believe the citation is at page 877. It's first head point, the wife's cause of action for loss of consortium, while derived from the personal injury to her husband, survives the death of her husband patient. What it went on to say, though, is it adopted basically what the underlying Capone case said, which is if you're going to file wrongful death, you have to file a completely new separate cause of action for wrongful death. Capone in the Florida Supreme Court comes back and says, no, you don't do that. You could file in the existing case, which is what essentially we've asked to do here.
If we know that a wrongful death action really does not survive the death of the decedent, and then you have to look to file a wrongful death action, and then you have to accumulate your damages or ascertain your damages under the Wrongful Death Act, right? And that would include damages to the spouse as well, wouldn't it?
Yes and no, because it depends.
So it would make eminent sense to say that if, at least to me, that if the personal injury action is no longer a personal injury action because the decedent died, and then the wrongful death action essentially can't be maintained because they didn't meet the time limits under the rule, then that would essentially wipe out the consortium claim too. So it seemed to me to make eminent sense to say that.
It does if you're talking about strictly a wrongful death claim, but remember, we have the alternative, the survival action. Survival action presumes that the injury that's alleged to be negligent did not cause or contribute to cause the death. In that case, that claim still survives, although it's no longer couched as a direct personal injury, it's couched in terms as a survival action, in which case a loss of consortium would survive. How now, if it's on the other hand, it's wrongful death? Sure.
The wrongful death claim, could she make a claim for the time she spent in essence, caring for her husband between the time of the incident and the time of the death?
No, I believe that the wrongful death damages start from time of death going forward. And the damages are different in that the loss consortium element of damages is very different from what you get in the wrongful death set of
The
damages.
only way, it's your argument that the only way she could recover for her services rendered, if you would, between the injury and his death was through this loss of consortium claim?
Yes, on the survivor.
Would come under the Wrongful Death Act. I mean, you can't separate it out that way and say,
Well, because remember that there's the 6 elements that you typically have in a negligence. Your loss of consortium claim basically gives you the mental suffering, pain and suffering. The wrongful death damages are a little different in terms of you look at the verdict form, where the wrongful death damages for surviving spouse are listed. It's loss of support and services, that kind of thing. So it's a different element of
Let's
damages.
say that the wrongful death statute would allow her to recover for that time period in between, including her services and loss of consortium and any pain and suffering during that period of time, then would it make more sense for it to proceed in the wrongful death case?
If you could prove wrongful death. In this case, it's disputed as to whether the injuries caused death or not. So we might not have a viable wrongful death case, and that's the prejudice to the plaintiff, because we would need to proceed on survival action. We can't prove it causes
He died
death.
for some other reason.
In this case, there's a dispute that he died from cancer, not from his injuries. Sorry.
But you do concede that that he is correct, Mr. Stein, I think it is, that Mr. Stein is correct, that had there been no doubt that the personal injury caused the death, that this would have been a wrongful death action, and she would have had to claim her damages under the Wrongful Death Act. There's no consortium.
Correct.
All right, we're just saying that you don't know, and therefore you need some more time to determine whether this is a survival action or whether it's wrongful death.
And we're entitled under the case law to plead it in the alternative, and we don't make the decision until the time of trial. At the eve of trial is when you make the election, I am electing to go for
You
survival or
disagree
wrongful
with
death.
that? Yes, sir. All right.
Thank you, Your Honor.
Okay. All right, everybody's time is exhausted, well argued on both sides. Okay, thank you.